Hi, and welcome back to this part 2 of our series on bankruptcy. So now we're going to look at ways to avoid bankruptcy, so alternatives, and we will also talk about the rights of creditors and the liquidation of assets. Okay, so let's start. Despite the fact that you have several ways to avoid bankruptcy, we'll talk about one in particular, but I want to mention that there are two types of proposals. Okay, there's the first one, which is called the Division 1 proposal or the regular proposal, and the one that we see or hear a little bit more, the consumer proposal. Okay, so basically, in the next few slides, you're going to have like the details of the Division 1 proposal. I'm not going to go through all the steps for the Division 1. Okay, I'll explain in general what it is. We'll look at the article in the BIA that talks about it, but it's very technical, very rigid as a type of proposal. But what can I tell you about it? Okay. The Division 1 proposal, what is important, okay, is that it is available for both for individuals, but mostly for businesses. Okay. It means if you are a business, okay, a business has no option but to do a Division 1 proposal. Okay, the consumer proposal we will see later is reserved for consumer debtors, meaning a natural person. Okay, so let's look at the section 50 of your BIA, paragraph 1A. So you see here, proposals subject to subdivision. Oops, I didn't want to do that, but anyway, okay. I'm just going to remove this. Subject to subdivision to subsection 1.1, a proposal may be made by an insolvent person. In part 1, we talked about the list of definitions in section 2. So let's look at what is an insolvent person. I'm going to go back up, go to my section 2 of the BIA, and we're going to, well, you're going to flip the pages and I'm going to scroll down until I get, to an insolvent person. Right here. It says, insolvent person means a person who is not bankrupt and who resides, carries on business, or has property in Canada. So it is a person. Okay. When I scroll down to the definition of a person, yes, I know I have to go into a definition to verify a definition. I know. But the definition of a person, it says a person includes partnership, unincorporated association, corporation, okay, then cooperative partnership, blah, 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 et cetera, et cetera. Okay. Liquidator, succession, administrator of the legal representative of a person. So here we are referring to both people and businesses. Okay. Just going to go back here to section 50. So the insolvent person we thought would apply to both. But trust me, as we'll see in a few minutes, if you have the option between a Division 1 proposal and a consumer proposal, you would much rather do a consumer proposal. Trust me. Okay, So in general, what is the idea behind a proposal, no matter which one it is? It's a contract between the debtor and all the creditors. So the debtor will offer through the trustee, will offer to pay an amount of money, which is usually less than the amount that is owed within a different time frame. Okay. So the idea behind it is that the person will reimburse part of the debt, which is usually more than what it would have been if it would have been a bankruptcy, but it's still less than the debt. Okay. So in the next, I'm going to skip the next 4 slides, okay? Because in the 4 slides, it talks about all the steps, which are very technical, okay? They're there for you because when I wrote the notes, I didn't want you to have gaps, but if this is not the focus of the course material. Okay, so don't worry about it. They're there. If you want, you can go and read them. But the point is just that if you want to know more, it's there. Okay, but it's not necessarily the scope or the focus of the class. Okay, so you will see. I'm just going fast because you have 10 steps. It's okay, so it's a 10-step program. One thing, and I think it's written in my slides later, one thing that you have to remember is if at any point there's a problem with the Division 1 proposal, for instance, it's not accepted by the creditors, or if you're in default of the Division 1 proposal, the consequence is automatically bankruptcy. Okay. So if you are under a Division 1 proposal and for any reason you don't make a payment for a given month, what is the consequence? You're deemed to declare bankruptcy. Okay, so it's very drastic. On the other hand, you have a consumer proposal. A consumer proposal is a simpler, more people-friendly option, okay, that doesn't have all the same consequences as a Division 1 proposal, but it's only offered for a certain category of people, okay? So there are criteria for it. In your notes, you have a link to a short video right here. I cannot play the video, not because I can't, I can do it if I wanted to, but because I'm going to post this on YouTube, and you know that YouTube I didn't request the permission from the owner, so I don't want to be accused of infringing copyright, okay, for presenting a video that is not my own. So, and because it wouldn't go well with our chapter 5 that we saw in IP, okay? So for these reasons, you have the link in your notes, and I'm gonna put the link in the description below for the video on consumer proposal. But if you go, you will see it's a short, it's a very short video. See, it's 2 minutes and 42 seconds. That will explain the difference between consumer proposal and a personal bankruptcy. Okay. So watch it after this presentation, and you'll be good to go. You'll understand. It's well made and very simple to understand. Okay, so the consumer proposal is a proposal that, if I just go down, I was telling you, it's open to only individuals. Okay. You'll see. Okay, we'll go into the BIA in a few minutes. So businesses cannot, under any circumstances, they cannot file a consumer proposal. A business must do a Division 1. Okay. So we have a simplified version. So let's go to section 66.11. 66.11, consumer proposal. Okay. So at 66.11, paragraph 2, it gives you the definition of a consumer debtor. It says an individual. So you see the difference. In the other one, it said an insolvent person. Now we have an individual. So it excludes any businesses. So an individual who is bankrupt or insolvent and whose aggregate debts, excluding the debt secured by the individual's principal residence, are not more than $250,000. You haven't done your Civil 5 class yet. So it's a little bit normal that a secured debt, okay, you don't know what that is. So I'm going to try to make it very simple for you. Okay. And don't worry, you'll have a very simple explanation. And once you get to Civil 5, you'll see that secured debt is far more complicated than what it actually is. Okay. So here it says an individual has a maximum debt of $250,000, excluding debt guaranteed by the principal residence. For us, okay, we'll keep it very simple. We'll use the mortgage. Oops, it's an R, M-O-R. Okay, so the mortgage, in case which technically we call a hypothec, a mortgage, okay, is when you don't have enough money. Like for instance, classic case, you want to buy a house, you don't have enough money, then you go to the bank, you ask them for a loan, and you say, in exchange to guarantee that I'm going to pay my debt, I'll give you my house as collateral. Okay. So juridically speaking, if you don't pay the house, if you don't pay your mortgage payment, what will the bank do? They will seize the house, sell the house, and pay themselves. Okay. So that is the principle of a hypothec, okay, which we call also mortgage. So for us, okay, when we'll do problems, let's say you have a problem on the final exam, I would use mortgage. Okay, that you would need to know that, okay, this is where we have to check. Where it says it is available only to individuals with that maximum of 250, excluding the debt guaranteed by the principal residence. So that means in total, I could have $200,000 worth of debt and 200 as a mortgage, and I could still file a consumer proposal. Okay, because I could have debt as a personal loan, I could have a debt as a credit card payment, all sorts of debts, and that in that calculation, in the 250, we do not count the mortgage on the main residence. How about a secondary residence? Aha, that mortgage counts toward the limit of 250. So if I tell you that I have a house, let's say I have a house in Longueuil on which I have a mortgage of $200,000. And I have I have a condo that I use in Bromont, okay, that I use in the winter to go skiing. Okay. If on that condo in Bromont, if I have $75,000 worth of mortgage, that mortgage counts. Why? Because it is not the mortgage on the main residence. The main residence is where I live. You know that. You've seen this in Civil 1. Okay. So we'll have a chance to work with this. So if I give you numbers and I ask you, can I file, could I file instead of bankruptcy, a consumer proposal? Well, it depends. We have to calculate what are all my debts, but I don't put the mortgage on my principal residence. Okay, so we'll have a chance to get back to this. The same way as I did the Division 1 proposal, except that in this case, I did it in the form of a schematic. It's coming. Hold on. Here. Okay, schematic of a consumer proposal, and you see where it goes. Without you having to go into all of these sections, what is important to know? Okay. See, for instance, I have filed my proposal. Well, if the proposal is accepted, it continues. If it fails or it's rejected, it's not an automatic bankruptcy. Okay, it says that the creditor's rights are reinstated. What does it mean? It means that my creditors can still come after me, because during the proposal, one advantage of the proposal is as soon as you file your proposal, it protects you against your creditors. Okay, so it means that if you were afraid of being sued, they can't while you're under the consumer proposal. Would be the same thing under the Division 1 proposal, by the way. But in a Division 1 proposal, if the proposal is rejected, you're deemed to file bankruptcy. Here, in a consumer proposal, you're not deemed to file bankruptcy. It just means that your creditors' rights are reinstated. That means if they want to sue you, well, then they can. So you see here, okay, creditors' rights are reinstated. Same thing here. Okay, so if there's any problem with your proposal, even if you fail, okay, the proposal, so it means that you start in one month, oops, you skip payment, you're in default. Okay, well then, your creditors' rights will be reinstated. Okay, so it is not a question of filing your, it's not a question of filing bankruptcy. It's just a matter of your creditors can come after you. Okay. So, hold on. Let's look at some of the differences between the Division 1 and the consumer proposal. As I told you, you'll have a chance to see it in the video. In the Division 1 proposal, there are things I already mentioned. So the first and probably most important difference is that the consumer proposal, so consumer, is available to a consumer debtor. No businesses. Okay. So no more than $250,000 worth of debt for the consumer, and that excludes the mortgage on your house. Okay. In a Division 1 proposal, the sky's the limit. Okay, you can have as many debts as you want. Okay, it doesn't change anything. Okay. Second difference exactly the one that I was telling you before. If you don't successfully negotiate a deal in a Division 1 proposal, you're deemed to have filed bankruptcy. Whereas in a consumer proposal, the creditor's rights are reinstated. And that doesn't mean that you cannot try a second proposal. So if you are doing a consumer proposal, if it fails, well, you can try another one. In a Division 1 proposal, it's a one-shot deal. If the trustee proposes that at the creditor's meeting and they refuse, bankruptcy. All right. The consumer proposal is less formal also, and it will minimize the costs. It costs a lot more money to do a Division 1 proposal than it does for a consumer proposal. Okay, because the process is simpler in the consumer one. Okay, so like for instance, if you compare the process that I gave you for both the consumer proposal and the Division 1 proposal, you will see that the meeting of creditors, they must have it in the Division 1 proposal, but in a consumer proposal, only if 25% of the creditors' worth amount in dollars, only if they request it. So that's one of the reasons why it costs less money, okay? Because most of the time, they don't have a creditors meeting. Okay. In a Division 1 proposal, you need to have the proposal. So first, there's a creditors meeting. The creditors must accept. If they accept, the proposal goes through, but it still needs to go to court. And then the court needs to approve. Okay, approve the approval from the creditors meeting. In a consumer proposal, the court is deemed to have approved, okay, unless it is proven otherwise. And then the court will hear it, but otherwise it's rubber stamping. Again, it costs less money because rubber stamping is less expensive than having an actual hearing. Okay. Okay. If you're very curious and you want to know, what I've done is that, see, here's a side-by-side comparison between the consumer proposal and the Division 1. Okay, so out of all of this, see, the consumer is only for individuals. One thing that you have to keep in mind, whenever possible, do a consumer proposal. Okay. Only if you cannot do a consumer proposal will you do a Division 1. People who do a Division 1 is because they don't qualify either, even for individuals, it's because they have more than $250,000 worth of debt. Okay. Or it's because it's a corporation. Okay, so that's pretty important. Okay, I often get the question, let's say the consumer proposal or the Division 1 proposal doesn't work. Okay, and a person must file bankruptcy. Let's look at, and there's probably some misconception, the right of the creditors. Okay. The creditors we saw in part 1, I've presented you with section 71, the property, the bankrupt's property is vested to the trustee. But there is a misconception that everything goes to the trustee. It doesn't. Okay. I don't want to do civil procedure 2. Okay. Well, first, because we don't have time to do it. Plus, I don't think your civil procedure 2 teacher will be happy if I've already covered the material. But I'm going to give you some general lines. Does everything go to the trustee? No. Okay. When we look at section 67, okay, so section 67, the property of the bankrupt. So what is not vested to the trustee? Many things. It says here, property held by the bankrupt in trust for any other person. Let's say you go on vacation. No, okay. After this semester, you decide to go on a trip for 3 months. And you say, you know what? I don't want to leave my car at my house for 3 months. So you ask me, could you, take my car, I'll drive it, keep it, start it once a week, and just make sure everything is okay. No problem. You leave on vacation for your trip, and while you're gone, I filed for bankruptcy. Okay, well, what's the problem with this? Well, I can't, even if, they come, I can't use your car and vest it to the trustee so that the trustee can actually sell it and pay my debt using your car, right? It is not fair. Okay, so you get the point. Okay, so if you give me something, I can't use it to make my own payments. Property that is exempted from seizure. Okay, so see, property again is exempt from execution or seizure within the law in the province. So we'll see that for us in Quebec, it's under the CCP. Okay. Payment relating to the essential needs of an individual. Okay. So if a person has receives money for disability, for instance. Okay. We'll see that for that part, there are always exclusion under a CCP and under the enabling statutes for each circumstance, but some of them are exempted from seizure, thus it is exempted from bankruptcy. Some are RSPs, not all of them. It depends on which what type of RSP it is, but some of them are exempted. So if they're exempted from seizure, they're automatically exempted from bankruptcy. Okay, so for that, we would need to check to see if a particular RSP is exempted from bankruptcy. Okay, so that's why I said some RSPs. The next few slides, I'm giving you the copy and paste from your CCP. Okay, so this is not subject to our material. Okay, and I know by saying that you've already stopped listening to me. But I wanted you to have a complete portrait. You will see that in the CCP, you will have things that may be exempted and things that are exempted. Okay, so 694, 95, 96, okay, are property that may or is exempted from seizure. Okay, so all of that, and you'll see the exempt from seizure. It doesn't mean because it is valuable that you can seize it, or the other way around. It's not because it doesn't have much value that it cannot. It's really according to all the different categories. Okay, but you will cover that. But for us, what I want you to know is that it is not because it is, if it's exempted from seizure under the CCP, for the same reason it's exempted from the application of Section 71 of the BIA. Okay, so you can't, the trustee cannot use that property to pay your debt. There is even the question of salary. So a seizure of salary, which we use, I don't know if it's called seizure by garnishment. I told you. Okay. It's been a while. I haven't cracked open much of a CCP. So there is particular rules regarding that. Also for family patrimony, for support, they have their own special rules, but that's the topic of next semester in your civil procedure 2, because you're doing civil procedure 1 now. Okay, now let's talk about the bulk of this chapter. Okay, the liquidation of assets and the order of payment of creditors. Okay, because that is the goal of the bankruptcy. Okay, the idea behind the bankruptcy is that they take the property of the bankrupt, sell it, try to collect as much money as possible, and then give that money in a certain order, which we'll see at 6.5, the order of payment. Okay, so liquidation of assets, there will be instructions that are given on how do we proceed. Again, for the sale of the property, it depends on what's the property. Okay, is it an auction sale? Is it a private sale? Is there any other way? What is the most appropriate? The way to sell property in lots, okay, is not the same thing as if you're trying to sell a business, for instance. Okay, so if it's a manufacturer, there will be lots, but if it's a building, it doesn't mean that they will use the same process, okay, to sell it. But the goal for this, okay, we have the property. The trustee will make sure that the property is sold, will collect money, and then once it has the money, we'll have to distribute that. So now let's look at how do we distribute that money. There is a particular order, okay, in which we should present the payment. Okay, there's an order of payment. And this is generally where, well, yes, you do have a final exam question. You have several on that, where you have to do an order of payment. So you have to play trustee, you have the money, and then you will have to distribute the money. Okay. So first things first, you have different categories of creditors. You have secured creditors, and you have unsecured creditors. Okay. Before we go into the definitions, I think I'm going to add a slide right here. So you have, oops, I've added 2 slides, one too many. Okay. So you have the secured, we'll call them category 1. In the second portion, you have the unsecured. Oops, sorry about that. Wow, okay. I'm not winning any prizes this afternoon with my handwriting. I usually don't anyway, but RED, unsecured. In the unsecured category, you have the preferred, and you have the ordinary. Okay. So we'll call that the second and the third. You will see the ordinary is what I will refer to the very unlucky category. Okay, because they don't have a rank. They are at the bottom of the list. So what does it mean? It means that when you have several creditors, we have to find, is there an order? So we pay first the secured creditors, then we will, by a vowel. Then we'll have the unsecured creditors. The preferred have a rank. So I need to pay this one before I can pay this one, before I can pay this one, and I will subtract my amounts. And I have number 3, the very unlucky. So for them, they have no, they have no rank whatsoever. They're paid all together if there is any money, okay, that we will divide, and there is a formula for that. Okay, so we will start with the secured creditors. Okay, let's talk about the secured. The secured are the lucky, or they are what we call the outsiders, okay, to the bankruptcy. They don't care. They already have, okay, they have their secured debt. It doesn't, that's why it's called secured creditor. Okay, for them, they don't care. They will get paid by the sale of the property. For instance, if there's the trustee is selling the house and there's a mortgage for $200,000 on the house, the trustee won't be able to sell the house below 200. Okay, so the secured creditors are guaranteed to get their money. I don't know if that's clear. Okay. So we have the secured creditors. So we say it's a secured creditor at section 2. Okay, oops, sorry, section 2. We have, if we go here, what is the secured creditor? So secured creditors. Here. So secured creditors means a person holding a mortgage, a hypothec, a pledge, a charge, or a lien. So the lien on this, for us, we will consider that a mortgage, like I've explained to you. So when I give you a problem and you'll have a practice problem, you'll see there's a mortgage. Okay, so we know that the mortgage is paid first. Then you would tell me, yeah, but what if I have 2 mortgages on the same house, which could explain. You learn in Civil 5 that the ranks is according to the publication at the land registry. Okay, I won't give you that. I could give you 2 mortgages, but on 2 separate houses. Like I can try to trick you and see by giving you the mortgage on a house and a mortgage on a condo. For us, since I will not specify, you can put the house first or the condo, it doesn't matter. What matters is that they will be paid first. Okay. So if I tell you that the trustee has collected $400,000 and there's a mortgage on the house for 150. Okay, well, then you start $400,000 minus 150. I have $250,000 left to pay. And you will go down your list until you have zero. Okay. So always the secured creditors first. Then we go to a very long list, okay, of in the unsecured creditors, the preferred ones. Despite the fact that they're called unsecured, okay, because it's not a mortgage, but they do have a cost. Okay, sorry, not a cost. I was reading my slides at the same time. Sorry, but they do have a rank. Okay, so the cost, again, the rank is listed at section 136 of your BIA. I'm gonna go just to show you 136. Scheme of distribution, priority of claims, subject to the rights of secured creditors, so that we know that they're first. So subject to that, here's the list. Okay, and we have a long list. The only thing that the article won't tell you is that see expense and fees and blah, 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 right there under paragraph 14.031A. In my notes, the only difference is that I put it in English. Okay. So instead, I said, okay, cost of administration, cost of this, cost of that. Okay. So the only thing is that in my notes, it's a little bit easier to understand. So let's go through those costs. By the way, does it mean that they will all be there? Obviously not. You may have 2 out of the whole list of 136, plus a bunch of ordinary at the bottom and 1 or 2 secure at the top. Okay, but let's go. If there are funeral costs, yes, I don't know, but it's there. So if you have funeral costs, it goes there. Okay, so if the bankrupt passes away during the procedure, the funeral costs will go first. Okay. Then you have the cost of administration. Okay, in cost of administration, it's divided into 3 elements. Okay, expenses and fees of the person responsible for the conservation of the property of the bankrupt. In English, it can be the interim receiver, okay, that we talked about in part 1. It can be, let's say it's the bankruptcy of a commercial farm. Okay, not a farmer, but a commercial farm. Somebody will need to take care of the animals. Okay, so if you have 100 cows, well, you're going to need to hire somebody. Okay, so why? But because I think I'm not an animal expert, but I think if you stop feeding cows or pigs or whatever, or chicken, after a while, there might be another issue that might diminish the value, right? Okay. So the cost for the conservation, okay, so to maintain, if it's a dairy farm and the cows are dead, well, they won't produce any milk, right? So get the point. Okay. The next one right here, the fees of the trustee. Believe it or not, to file bankruptcy is not free. The trustee will charge an amount. So of course, when the trustee is looking at your debts and he's looking at your revenues or your assets, he's going to do a quick calculation as to, okay, can I at least get paid? Because if it stops before that, he won't be interested in taking your bankruptcy. And you cannot file bankruptcy without a trustee. So it can be a catch-21. Okay. If you don't have enough money to pay the trustee won't take your fund. It won't take your file. If they don't take your file, then you cannot file for bankruptcy. Okay. Sorry. So here, the third one is the legal costs. Okay, so the stamps and all of that. If there is any situation where I wanted you to put an amount there, I will tell you there is a legal cost of $400. Okay, so you would know, you would be able to recognize it. Levy payable to the superintendent. That is an amount of money that you pay to the superintendent to manage your file. Okay. There's nothing free in life. So if I say there's a $500 payable to the superintendent, it goes there. Okay. This one is where sometimes I have students who are having problems. At D, it says wages, salaries, and commissions for a maximum of, so it's the first one, either a maximum of 6 months prior to bankruptcy or a cap of $2,000. Okay. So if I tell you that there is an amount, Laureen hasn't received her salary for 4 months for a total of $3,000 a month. How much is she owed? A D? $2,000. Because the cap is either 6 months or $2,000. So the first one that you cap is, in this case, $2,000. If it were, Laureen hasn't received her salary for the last 9 months for a salary of $100 a month. What is the cap? 600. Why? It's 100 a month. And since we're not going to reach the 2,000, we have to stop at 6 months. So after 6 months, $100 a month times 6 months, believe it or not, it's 600. If you don't trust me, take a calculator. Okay. In the first example I gave you, let's say she hasn't been paid for 4 months at $3,000 a month. We said what would be the amount that we would put at the line for D would be 2,000, right? But in reality, is that what she is owed? No. I said 4 months at 3,000 a month. That is a total of, yeah, that's it, 12,000. So she's allowed to have or to put 2,000 at the line for D. What happens to the other 10,000? The other 10,000 we will put. So any excess, we put it in the third category, the ordinary creditors or the very unlucky. Okay. So we will put the max in the preferred. And we will keep that in mind for the excess at D goes in the pool of the ordinary creditors. Okay. Same thing for D.1. D.1. It says alimony, alimentary pension, or affiliation payable in the year. So there's again a cap. It's 1 year. Okay. So if I tell you that Maria hasn't received alimentary pension or affiliation for $2,000 a month for 15 months. So she hasn't received $2,000 a month for 15 months. How much do I pay at D.1? $2,000 a month times 12. Yes, you're correct. Why? Because it says a year. $2,000 a month times 12 is 24,000. 24,000. Oops. Come on, come on. Here we go. Okay, so it's 24,000. But I said 2,000 a month, 2,000 a month times 15 months. So we can put only 12 in the preferred. But the last 3 months, 13, 14, and 15, that's $6,000. So 2,000 a month times 3, because it's the excess of 12 months. So there's 3. That excess goes again at the bottom with the excess also in salary. Okay. Don't worry, there is a problem later with actual numbers. The municipal taxes, and again, it doesn't mean that they're all going to be there. Okay. So municipal taxes, it says 2 years. If it's more than that, the excess goes where? The ordinary, yes. To lessors for IRS of rent in the 3 months, another cap. 3 months prior to bankruptcy, and 3 months to come if the lease contains a clause of accelerated rent. Don't worry. If I give you a problem with that, I won't, because you don't have the lease, so you don't know what's an accelerated rent provision. Okay, so for us, 3 months before bankruptcy. So again, if you owe $1,000 to the lessor and you haven't paid for 4 months, the max here that I can put is 3,000. Here we go. Where's the extra 1,000? Yes, it goes at the bottom with the ordinary. And we're going to add all of this after. G. If there's any cost incurred by a creditor for asset seizure on their way at the date of bankruptcy. So this would be the case where a creditor is in the process of an application for bankruptcy, okay, like a forced bankruptcy. And halfway through it, okay, or if there is a, what else, a cost incurred by a creditor for asset seizure on their way at the date, sorry. Let me start over with the problem. At G, if you already have let's say one creditor that is seizing, like it is seizure before judgment type of thing. There's a cost for that seizure. If in the meantime, the debtor decides to go bankrupt, the amount, so if it was like $2,000 worth for the seizure, well, that $2,000 for the creditor. Okay. So in other words, if there's already a seizure and while there's a seizure in progress, the person files bankruptcy, the amount of the seizure would go there. Okay. It's unlikely, but it's there. Okay, H, you can kind of forget about it. Certain debt, if the bankrupt became bankrupt before the prescribed date, the prescribed date is November 30th, 1992. Okay, for that, this would only be in the case of a bankruptcy of a corporation. Okay, so for that one, usually what I tell students is that you can cross that one out for at least for now. Okay. Claims resulting from injuries to employees in the of the bankrupt in respect to which the provision of the act respecting the workers' compensation do not apply. Okay, so if there's a work-related injury, but it doesn't fall under, or it is not recognized by under the Workers' Compensation Act. So for us, the compensation in this case would be, if it's you have a claim of $4,000 against your employer, and it is rejected by the under the Workers' Compensation Act, then it would fall here. Another thing that is unlikely. Okay, but still. The last one is J, and let me do this again. Okay. It says in the case of a bankrupt who became bankrupt before the prescribed date, claims of the Crown not mentioned in paragraph A to I. The prescribed date is November 30th, 1992. Okay, so these would apply corporations that will never pay. Okay, so I'm not training you to become trustees. Okay, so and the rest, okay, concentrate on that. You'll see the different problems that we'll do. So after we've paid everybody at 136, okay, so at 136, we're gonna pay all the unsecured creditors. Okay, the funeral costs, the salary, the municipality for taxes, the landlord, etc. So we're going to subtract these amounts each time. Then here in the unsecured creditors, this is what we call the ordinary. Okay, oops, sorry about the that's supposed to be an N, and that's supposed to be an R. So the ordinary creditors, we're going to put them in a pool and we will pay them, okay, proportionally. There's the calculation, I think, is on the next or the page after. If we still have enough money to pay all the unsecured creditors, we would give back the rest if there's any excess of money. Okay, any surplus goes back to the bankrupt. And here, this little guy that is crying, this one is because, well, he's an ordinary creditor. Here, I should have put a smiley face. And then I should have said, haha, because that never happens. okay, that you were able to pay all your debt, and at the end, you still have money. Because usually, if you have enough money, you won't file for bankruptcy in the first place. Okay. So let's look, we'll take the exact same thing and we'll look at this with numbers. Okay. And then we'll call it quit for today. Okay. What I invite you to do is you can follow with these slides. And if you have your phone, it's not for texting, but a calculator. By the way, on the final exam, you will need a calculator. You are not allowed to use your phone for some obvious reasons. Okay. So here's a list. And here's the problem. How do I do the calculation for the unsecured creditors? So I always need to give you how much money does the trustee have? Because the trustee has to distribute that amount of money. Okay. So there's always a starting point. In this case, it's $325,000. Then I give you a list of debts. Of course, I'm not nice enough to give them to you in the correct order. Okay, so I'll give you a bunch of amounts. So see here, I have $250,000 for a mortgage on the main residence. Mortgage. That sound and reminds me of something. $25,000 to MasterCard, $40,000 to Visa, $37,500 in alimony to Suzanne. So this is composed of $2,500 per month. $6,000 in property taxes for the last year. And $7,000 to Boudreau-Legault trustee. The first thing that you will have to do is put them in the correct order. Okay. So when you have a problem like this, maybe the first thing that you should do is look, okay, do I have anyone that potentially could appear in two categories? What do I mean? Like one in preferred and an potential excess in the ordinary at the bottom. Okay. So the mortgage, well, okay, I know it's going to be first. The mortgage is outside bankruptcy, so it's paid first. Let's try to see for the others. MasterCard, it's a credit card. Did we see anything about credit cards in 136, like on the previous page? No. So I will put O for ordinary. That means the unlucky ones at the bottom. The Visa, same thing. It's an ordinary creditor. Oh, alimony. There was something. So alimony, I know, is preferred. Okay. But I'll put O. Do I have anything to put in ordinary? We'll see. Maybe yes, maybe no. We'll calculate after. Taxes. I know taxes. There was something about taxes at 136. but there was also a delay. We'll see. Do I have to put anything? So I'll put O and again a question mark. And the trustee, I know that one was a P, so it's a preferred creditor. Okay. So now, sorry, let's put them in the correct order with the amounts. So BMO is a secured one. That was the first one, and we knew that one. Then out of my list, what you have to do is you take your BIA 136. I have students, what they do is that they print the page from the notes just before, so that they don't have to go from one screen to the other during your exam, because your exam is on Brightspace. So if you want to print the the long page with all the creditors and the explanations, this one right here, if you want, you can print that slide alone. Or in your case, I think it's several slides. I think I've cut it so that it wouldn't be too small. Okay. So I have people sometimes will, and during the final exam, they're going through it and it's a bit easier. Okay. So when we go down the list of 136, the first one that we find is the trustee. Okay. So the trustee goes for 7,000. There's no maximum. Okay. Then we said on the previous page, for Suzanne, for the alimony, it said 2,500 per month for a total of 37,500. Take your phone, go, find your, like me, find your calculator because it's not an exam. So 37,500 divided by 2,500 or by 12. Aha, it's 15 months. There was a catch. So 37,500 divided by 2,500 is 15 months. So I have an excess of 3 months. So it's 2,500 times 12. Let me just, I'll try something. Yeah. Okay. So here in my category, I will need to put 30,000 here because it's 2,500 per month for 12 months. But I have a 7,500 in excess that I need to put in my ordinary creditors. Then I had the taxes for the last year. It's okay because at 136 it says for 2 years. For us, it was only one, so the 600 in total. So now, again, take your calculator. Come on, do it. So what you'll do, you have to pay your creditors. Remember, at the beginning, we started with the trustee at $325,000. Sorry, that's my screen. Here we go. $325,000. $325,000. Okay. From that, remove, so subtract $250,000 for the mortgage to BMO. Then minus 7,000 for the trustee. So I'm going to pay the trustee in full. I still have $68,000 minus the 30,000 that I'm going to give to Suzanne. I still have 38,000. So I keep going. The next one is minus 6,000. It equals 32,000. So after paying my secured creditors, well, I only had one, so my secured creditor, and all my preferred creditors, so the one on the list of 136, the trustee has $32,000 in his pocket. But we're not done yet. There is a bunch of other creditors. So I have paid all my creditors, well, all the preferred and secure creditors. See, that the 325 is what I started with, minus the mortgage, minus the money to the trustee, minus the alimony to Suzanne, minus the taxes. I am left with the same amount, okay, 32,000. Yes, there are short routes that you could take, but I'm doing the long calculations. So, because I have always students who are afraid of calculators. Yeah, if you have a shorter when you're getting to the same numbers, I feel you, go ahead. So after paying all of this, who do I have in my ordinary creditor category? All right. These are the ones that we didn't talk about before, or the excess. For instance, the excess of alimony. So in our case, we had 25,000 for MasterCard. It's an ordinary creditor. $40,000 to Visa. 7,500. It's the excess. Remember, the debt for alimony was 37,500 at 2,500 per month. So we took that in the preferred creditors. We put the 12 months, which was 30,000. So the excess, the 7,500, goes in the unsecured creditors. So when I add 25,000 plus 40,000 plus 7,500, I have a total of 72,500. This is the total debt of my category of ordinary creditors. This is how much I owe. The problem with this is that when I looked in my piggy bank, I only had $32,000. So we remember, I started with 325,000 minus everything that we had so far. I was left with 32,000. So I have 32,000 in my piggy bank. Unfortunately, the debt are 72,500. So I have more, I still have more debt that I have money in the bank to pay all of those. So I don't have a choice. I'm gonna have to pay them proportionally. Okay. So let's recap. So using the order, so that is the secured creditor, the preferred, the list of 136, you go through all of them until you have no more money. Okay. So we start by paying the secured creditors. They are outsiders. I go down my list. Once I go down my list, I check, do I have any money left? That's why it says right here, if you have money left, you will have to do the calculations for each unsecured creditor. So the Visa, the MasterCard, and the alimony. So how do I do that? It's very easy. It's a proportion. Okay. So I started with 325,000 at the beginning. I have 32,000 left to pay 72,500. Here is my formula. So when we do it the long way, I will do that for each one, and I invite you to take your calculator and do it with me. So for each one, so for MasterCard, when we looked at the problem before, MasterCard, the debt was 25,000. Oops, there's a zero right here. The total amount for the pool of the unsecured creditor is 72,500. 72,500. And how much money left do I have? In my pocket, I have 32,000. So when I calculate this for MasterCard, so 25,000 divided by 75,000 to 500 times $32,000, or the other way around. Okay, you can multiply 25,000 by 32 and then divide it by 72,500. Okay, it will give you exactly $11,034.48. Okay. To do it, I'm not going anywhere. Okay. You may have to round your numbers up. Okay. So now what do? You do the exact same thing for Visa. So you take the exact same formula, except this time the debt, the original debt to Visa was 40,000. So when you apply this with Visa, it will give you exactly $17,655.17. Then alimony, 7,500, which was the excess. So 7,500. And you do again the calculation. They'll give you $3,310.35. Okay. So how do I know if I have the correct numbers and if I round them up properly? Well, $11,034.48 plus, sorry about that, plus 17,655 and 17 cents, plus $3,310 and 35 cents equals exactly 32,000. And it's normal because if I add up how much will I give to each unsecured, well, ordinary creditors, I will end up with the original amount that I had in my pocket left to pay them. Okay. So what I invite you is to go over this, okay, with, wait for it. You can come back to the end of the video. Just go back into the numbers. When you will do your practice exam, you have a problem like this that you will have to do with all the calculations. On an exam, obviously, you have to give your calculations. If you give me only a number and you're wrong, I cannot give you partial marks. Okay, but if you give me the calculation and I see where you made the mistake, at least I can give you half of those marks. Okay, so that is it for part 2. We will need to go, when you come back for part 3, we will talk about what is the discharge and the surplus payment. Okay, so I'll see you next time.